This presentation is concerning researching the law. It's covered basically with the book Researching the Law, Finding What You Need When You Need It by Amy E. Sloan, 2014 copyright of Wolters Kluwer Publishers. This first presentation covers the American legal system, part 2. I have set out some goals that I want to reach by giving this presentation, and I should add that while this does cover Chapter 2 of that particular book I just cited the name of, the presentation is also has some embellishments I've added and provided here to help expand your understanding of the concepts in the textbook, and also to expand your understanding of how the general concepts of the book apply to Florida researching of the law. But this is a list of the general goals that I hope to achieve, or I'm sure you'll achieve from listening to this presentation. For example, describing what precedent is, explaining the difference between primary and secondary authority, explaining the difference between binding and non-binding authority, the difference between mandatory and persuasive authority, and relate those terms that I just listed off to the areas of the Florida court system. And then also, of course, we need to just very generally describe the actions that appellate courts can take regarding the lower court decision. There are 4 main sources of law. These are the law itself. These are the rules created by government entities that govern conducts in society. They please recognize that the varied sources of law mean that researching a legal issue may require you to research several types of legal authority. So something may be constitutional, but there may also be statutes that apply to the same problem. At the same time, the court's opinions of other cases, whether it be common law or a court's interpretation of a statute or constitution, may also go into the research process. So this presentation, however, will focus mostly on case law because it's an area that will help you understand the hierarchy of the courts and the application of that hierarchy to some really important concepts of mandatory versus persuasive authority. This task, this filtering process, is one of the first areas you need to understand in order to continue in a research program such as this course. Also, sometimes you will hear the term primary law. It is interchangeable in many respects with each of the sources of law. So constitutions, for example, statutes, court opinions, and administrative regulations are, in a very general sense, called primary law. Secondary sources, which we will be covering in a later chapter, they're listed here. Secondary sources are not primary sources. And the reason for that is they're not the law itself. Secondary sources are a research tool or a learning tool if you want to learn commentary about the law. They're an excellent starting point for research. I often start students on secondary sources, especially when you're dealing with areas of the law that you really don't know. The other thing I should add that isn't on this list and wasn't included in the book, but your textbooks for all of your courses it's in the paralegal program at State College of Florida are secondary sources to help you understand the law a little bit. The ones listed on this slide, however, are going to be more robust, more detailed, and have a lot more references to cases, statutes, and other primary sources. So it's just a difference of, what level you need to start at. And sometimes your textbook is a really good place to begin doing your legal research to make sure that you understand the problem. As with all of your courses here at State College of Florida, I'm going to give you another quick lesson, down and dirty lesson on the branches of government. And legal research is the one area where this begins to crystallize a little more with students. Why do they keep telling me the branches of the government. I think I understand. I get it. Hand me my diploma already if this is all I have to learn each semester in the first class. But just bear with us, because this is one of we can't research the law if we don't know what governmental system we're working with, and what branch of the government that's created by the United States Constitution, for example. So just briefly, the federal government has an executive branch, a legislative branch, and a judicial branch. Each of those branches have their own, are permitted to make laws in the areas that are directly below the branch itself here in this slide. The next slide is simply recreation of a state government. Note that the federal government and the state governments are similarly organized, and the branches have identical duties in making law. We'll add that another terminology that comes up in the book, that to keep you in understanding, sometimes they use the term enacted law, and when they're referring to enacted law, they're referring to statutes, more or less. Now, this slide is very briefly one to help illustrate for you binding authority and binding authority and non-binding authority. Recognize that binding authority and mandatory authority are synonymous terms. Also recognize that non-binding authority and persuasive authority are synonymous terms. So later in this presentation, we'll discuss more about the terms of this chart, but this chart should help you categorize the sources of primary and secondary law into the important filtering process that goes on in your head when you're doing your legal research, when you want to make sure that you are looking at the right weight of the law, whether it be binding or binding / mandatory, non-binding / persuasive. So again, synonymous terms. This chart simply illustrates the sources of law that you would go to if you were looking for primary authority on something or secondary authority. All right, cases is where we begin. Most legal research classes start here. In our regular research class, I know that we often start with statutes. It's in some law school research classes do as well. But I'm going to start with cases in this class as an exception to that general rule of mine, and that cases help us to understand something really important to the research system, the research process, and that court systems operate hierarchically. One second here. All right, court systems operate hierarchically. Trial courts are bound by the decisions of the two higher courts to which their decisions may be appealed. Intermediate courts are bound by the decisions of the highest court. In other words, what I'm trying to illustrate is these in the federal system, these United States district courts, those are trial courts, and they're bound by the decisions of these appellate courts, which is an intermediate court of appeals. Of course, the United States Supreme Court is the supreme law of the land, the court of last resort, and even though the cases move upward if they're being appealed, the pressure to follow the opinions or the decisions of the higher courts is a downward pressure. Note that some states, this is the structure of most state court systems. They have a trial court, like the federal court system, an intermediate appellate court, like the federal court system, and a court of last resort. Please realize that the same binding effect of the decisions applies on the state court systems, and we'll have a much more narrowed focus to that at the end of this, closer to the end of this presentation. Also note that some states do not have an intermediate appellate court. The illustration you see now, the structure of most state court systems, is what the Florida state court system looks like. It is a three-tiered court system in Florida. Other states, Wyoming is an example I often use in this class, has only a two-tiered court, meaning that there is no intermediate appellate court. It's the trial court, skip that little area there and go to the Supreme Court. So some other states do as well. I think the book notes some other states that have two-tiered court systems. So no intermediate court in some states, but Florida has an intermediate appellate court called the District Court of Appeals. All right. This chart illustrates that case law opinions, in other words, we're looking for on-point authority. We're looking for a case when we do research into case law that resembles our case, applies the same facts and the same law. This chart helps to illustrate that case law opinions have weight based on the jurisdiction and the hierarchy of the court system. Trial courts conduct trials and decide on motions and procedural aspects of cases that are filed in those courts. However, trial courts do not write opinions. Only appellate courts make case law. After a trial is had, or if there's an order on a motion entered, a record of the trial is made. And if there is an error of law at the trial court, then a party may sometimes appeal the decision of the trial court. In criminal cases, there's some limitations on the appeals. We won't go into that in this class, but recognize that. The main point of this illustration, however, is to learn that generally the highest court of a state or the federal court makes decisions, and they publish these decisions by the medium of a case opinion. And these are binding. When the federal court makes, the highest court of the state or the federal court makes a decision in their through case opinions that are binding, and the intermediate appellate courts also make case decisions that are binding. Later in this presentation, we'll look at this general concept with a more narrow focus so that we can recognize that the highest court always has the last word, and the intermediate appellate courts may have limited weight. Their opinions may have limited weight. The highest court will have the last word, and they have a higher weight. And the intermediate appellate courts also have limited weight in terms of their geographical boundaries. But don't worry too much about that now. Just recognize as an introduction that very pure and simply this is true, that we have a trial court, intermediate appellate court, and a highest court, and off to the side, we see the notation that opinions are primary case or primary law, that they're binding and mandatory authority on this side, but they're binding and persuasive on this side. That's not always true if we look at some court systems like Florida and the way that we recognize geography and boundaries. We'll look at that more clearly in a little bit. All right, so the organization of what we call legal authority, we have to look at what we call jurisdiction. Jurisdiction must be looked at in light of the type of law and also in light of the courts. So jurisdiction is the authority and power to apply specific types of law, of governmental bodies to apply specific types of law. These include federal, state, criminal, administrative, or civil. These are types of law. So jurisdiction is the authority and power to apply specific types of law in a specific geographic area. The power and authority of a court to hear and decide a case is how we define the term jurisdiction when we're talking about courts. All right, so we have jurisdiction in terms of the type of law and the authority and power to apply it. When we look at courts, we're looking at the power and authority of a court to hear and decide a case. And that's what we look to, that's what we mean by jurisdiction in that vein. In the previous slide, I pointed out that there are 2 or 3 tiers of courts depending on what governmental organization you're researching. For example, federal is the 3-tier, Florida as a state is a 3-tier, other states are a 2-tier. Constitutions and statutes are what define the jurisdiction of courts. So all this kind of comes together as a jurisdictional thing that you have to understand. Moreover, jurisdiction, as shown on the previous slide, is not just the ability to hear a particular type, but about the level of the court, whether it's a trial court, an intermediate court, or a court of last resort, the Supreme Court. Each of the sources of law are organized in what we'll just loosely term a database. A source of law is a set of books, if you will. And a set of books is a database. And these books can be electronic too, and those can be a database. So they're published that way as sources, and sometimes by subject. And this organization is of these databases, be they print databases or paper databases, are done by jurisdiction and by the type of authority. So if we were going to go look at that, the organization by jurisdiction, we might have the jurisdiction of the government authority or power, like statutes. So that would be the Florida statutes, for example, or the type of authority, the statutes. In other words, they're organized by both jurisdiction and the type of authority, and there's some overlap between them. When we want to consult one of these publications, we look at what we call the citation of the source. In your textbooks, if you've taken general law, in your textbook, there have been citations for the contracts to the Uniform Commercial Code, or in torts to a case like Catco versus Briney. And of course it has some numbers and a reporter name abbreviation next to the name, but that's a citation telling you where to find that particular authority. And this citation works as an identifier, and probably you may not have thought of this yet until you got into this class, but really they're pointing you, by writing out the citation in the format that we write it in, we're telling you a lot about the jurisdiction of the case, and we're telling you if it's a case, for example, and we're telling you possibly the type of authority. If I'm looking at a citation to Catco versus Briney at, I don't know what reporter that's in or the page number, I'm also telling you where to locate it. And I learned from that also, if it's properly written as a citation, it identifies what state it's from, what year it was decided, possibly what court decided it. It's not an easy picture to see until you learn about citation, which we'll start doing soon. All right, so it's an identifier that helps us understand both the jurisdiction and the type of authority. I look at a citation to the Florida statutes. I know it's a Florida statute, and so I know that the authority is a statute. I know the jurisdiction is Florida. Okay, so when we're looking for law, we're looking for what we call on-point authority. So we're looking for a case, and a case would be considered precedent. Precedent being a prior opinion of the court involving the same or similar set of facts as the case that you're researching for. So precedent guides the court to decide the case, and this whole idea of precedent is embodied in the decision, in the stare decisis. Stare decisis is a legal concept. It's a Latin term, which literally means to let the decision stand. So if in the past we've done it this way, we should continue doing it this way, unless there's a good reason not to do it this way, as done in the past. On point means that the facts of the prior case opinion and the facts of the client's situation are sufficiently similar, and it's also referred to as analogous or on all fours. So on point means that I found a case during my research, it's on point, and the reason it's on point is because the facts of the case that's on point, the prior case opinion, are similar to the case that I'm trying to resolve now using that opinion. So these two terms are presented together so you recognize that precedent is the prior decision, and that prior decision should also be on point. You can't compare apples to oranges, you have to compare apples to apples to keep it simple. All right, this chart's a handy little chart for when you're doing your legal research. The top of the form is, again, we're looking for primary authority, we're looking for precedent, we're looking for on-point precedent, and at the same time we're looking for precedent that is of primary authority. Because if it's a primary authority, if we're looking for precedent, we're looking for on-point precedent, and we prefer primary authority that is mandatory. There are times when even primary authority is only persuasive, meaning the courts are not bound to follow it. And we're going to go into more of that, but this chart is a great sheet to have as a new researcher while you're researching, to see if make sure you have a checks and balances, to be sure that whatever you're researching, you're finding primary authority and knowing under what circumstances it's mandatory in terms of the court must apply it, or persuasive in terms of the court may apply it. All right. And also note that this chart normally has a list of statutes, and what I'll do is I'm posting the full chart online in the course. So please find that full-size chart, and there are some footnotes on it which are explanatory of these asterisks. And I won't go into that now, but you read it and you'll probably understand it just fine. All right. Okay. So binding versus non-binding authority. Let's relate all of this to our state, the good state of Florida. First of all, as I've noted more than once in this presentation, Florida is a three-tiered court system, meaning that we have a trial court, above that we have an intermediate appellate court, and we have a Florida Supreme Court, the court of last resort. Binding authority and mandatory authority, binding authority and mandatory authority, by the way, those are synonymous terms. Non-binding authority and persuasive authority, those are also synonymous terms. So if it's binding, it's mandatory. The courts have to follow the principle of the precedent that you are citing to in your research. If it's non-binding authority, it's persuasive authority, and the courts are not bound to use to apply the law that you've asked them to apply in your research. Recall the three-tiered court system and our intermediate court of appeals and the court of last resort. This Pardo versus State is a case that I'm going to upload into the course as well. Pardo versus State is a great case. I've used it for years to help students understand a few important concepts that we've talked about so far as it relates to the Florida cases, or the Florida legal system. One, the central concept is that on-point cases are discussed in this in the Pardo versus State case. The problems that develop from what we call inter-district conflict of laws. We'll go into what that means in a minute. Hierarchy of decisional holdings of courts in Florida is important to understanding how to do research, as well as binding authority. And we know what that means already. Binding versus non-binding. Pardo versus State involves 6 legal issues. All right. Now, when you become a more experienced researcher, you'll learn that cases that you read, case opinions that you read from the courts, will often cover more than one legal issue. And so I want to make sure you narrow your focus when you read the Pardo versus State case to the text of the court decision where you see the first issue. And there's a head note. You'll learn more about that as you go along. But there's a number 1. It looks just like this on the case copy that I'm giving you a copy of. And it says courts. And then later on the page that has that section, you'll see the court's opinion regarding that particular topic. And so don't worry about anything else you read in the Pardo versus State case. Read the section under head note 1. And I will highlight that or something on what I upload into the course. First of all, recognize that this case confirms what I've been telling you already, that the district courts, which are trial courts in Florida, we call our trial courts district courts, they rely on precedent. That's not a big surprise. We just talked about that in the previous slide. The highest level of precedent is from the Florida Supreme Court because of the 3-tiered nature of our court. If there is no precedent from that when you're researching and you cannot find a case that is precedent, which would be an on-point case from the Florida Supreme Court, we defer to looking for precedent from the intermediate appellate courts, and those are called district courts of appeals. I will correct this slide. Actually, our circuit courts are trial courts, so I need to change this word. You need to change this on your notes. This is the circuit courts, not district courts. But if there is no precedent from the Florida Supreme Court, we defer to relying on the precedent from the District Court of Appeals, which is the intermediate court. So reading this case of Pardo versus State will help you understand this filtering that we do, pre-search and post-search. When you're doing your search for case law that's on point, first you want to find that on-point case. Second, you want to be able to apply the case that with the proper jurisdictional weight in order for the case to be binding. Without that jurisdictional weight, the case may... All right. These central concepts, I'll move on to. If there is no precedent from the Florida Supreme Court, which is the highest level of court in Florida, we rely on precedent from the District Court of Appeals. Trial courts in Florida, they're organized geographically, and then they're clustered into 5 separate geographical district courts of appeals. So if I'm in Manatee County, I'm in a trial court. If I'm in a Manatee County trial court, I am in the 12th Judicial Circuit. If I am, that's a geographical location that's clustered into separate geographical district courts of appeals. That's the intermediate appellate courts. We also call them DCAs. So when someone says DCAs, they're probably talking about the district courts of appeal in Florida. All right, so the important thing also to recognize is cases decided by district courts of appeal are not binding on the the court of last resort, the Florida Supreme Court. In other words, a Florida Supreme Court gets the last words. So the central concepts of binding versus non-binding authority are explained in the Pardo versus State case. Remember, the precedent from the Florida Supreme Court would be the highest level of the court in Florida. All decisions from this court of last resort would be binding authority for all other courts in Florida. If we see a case from the Florida Supreme Court, it is binding authority for all other courts in Florida. The Florida Supreme Court gets the last word. Precedent from the lower appellate courts, we call them again the DCAs, they're not binding. Moving upward, they're not binding on the Florida Supreme Court. If there's a conflict between the laws of one district from the Florida DCAs, I'm talking about the intermediate district, we call this inter-district conflict, So if the second DCA and the third DCA each have a conflict of precedent, the Florida Supreme Court would be able to resolve that conflict. But if you're researching for cases and you find a case on point in a sister district, for example, I'm in the second district, to the jurisdiction that you're researching to answer a legal question, the second district, and I find something from the third district DCA, it would only be persuasive, which is non-binding authority. All right? So Florida is, and other states are not, by the way. And she points that out. You don't really know it when she points it out, but the writer of our book, she makes a note of that not all states are this way. But your binding authorities come from your own intermediate district court of appeals whenever there is no Supreme Court decision above it. All right? So if you find a case on point in your own jurisdiction, from your own jurisdiction, which for Manatee County would be the Second District Court of Appeals, it's binding in Manatee County, if in the trial courts of Manatee County. All right. In practice, when you're looking for precedent, you would want to start with making sure that you look to the Florida Supreme Court, because that's because of that, the situation I just explained in the last slide. Because the highest level of the court in Florida, and these are the decisions from this court of last resort, are binding authority for all other courts in Florida. The Florida Supreme Court will get the last word. Precedent from the lower appellate courts, again called the DCAs, they're not binding on the Florida Supreme Court. If there's a conflict, we call that the interdistrict conflict, the Supreme Court would be able to resolve it. And just remember that binding authority and mandatory authority are synonymous terms. All right? So in practice, you would begin by looking for a prior case opinion. And here's, in practice, if you're looking for precedent, which is a prior case opinion that is on point to apply, for example, in the Manatee County trial courts, you want to locate a case on point in the Second District Court of Appeals, because that's where Manatee County is geographically located. Unless you can find a case on point that's located from the Florida Supreme Court. A case in the First, Third, Fourth, or Fifth District Court of Appeals, those are called sister districts to the Second DCA. So those would only be persuasive in Manatee County. So they're non-binding. The court in Manatee County does not have to apply it in Manatee County trials. Okay? Step one, the highest court of the state is the best place to find precedent, because it applies to all courts in Florida. If your second best choice would be to find a case in your own district court of appeals, and then you know you have binding authority. If you do not find one in those two places, you would obviously be finding precedent from a sister district to your district that you're researching for, and that sister district is only persuasive. So sisters are persuasive. So here's an example. You're researching to find out a question of law involving a contract case in Manatee County. So you're working for an attorney, you're doing some research, and it's involving a contract case, and you've looked to that case and you find controlling, and controlling means it's binding, authority right there in your jurisdiction. You find the Bobson versus Turner decision from the Florida Supreme Court. That case is directly on point with your case facts and law applied. So you read the case of Bobson versus Turner, you go, wow, this sounds just like the case I'm researching. It's analogous, it's on point, it's on all fours. One of those three terms would be where your mind is headed. You're like, yay, I found this case, and it is mandatory binding authority. It's also primary authority in Manatee County trial courts because it comes from the state's court of last resort. All right? Taking another example another step. You're researching to find out a question of law involving a product's liability case filed in Manatee County, Florida. You look to case law. You want to find controlling, binding authority, a case that's on point, that's in your jurisdiction. But you come across the Smith versus the Widgets case, or the Smith versus Widgets Inc. case. So you say, wow, it's from the 5th District Court of Appeals. It's on point. It says it's in this case, that the Smith versus Widgets case has similar facts, applies similar laws, and I want to ask the trial court, or my attorney wants to ask the trial court in Manatee County to apply it because it's on point. It's analogous. It's on all fours. And it's all you can find. You went to the Supreme Court of Florida, you couldn't find anything. The only thing you could find was an on-point case from the 5th District. Well, the 2nd District Court of Appeals, it's not a case from the 2nd District Court of Appeals, so it is merely persuasive law. Even if it's on point and it says exactly what you want it to say, and you're like, we won the case. We have an analogous case. It says exactly the same thing. It doesn't. It's only persuasive. It's non-binding authority. So that's how the Florida courts work with that. If you're researching, note that if the case you are researching for is filed in a county within the 5th District Court of Appeals, then it would be, if you were actually looking for the answer to the case that's filed there in the 5th District, it would be binding authority. But it's simply persuasive if you're looking to ask the court to apply it in a county in the 2nd District Court of Appeals. All right? So that's what you're looking for the whole time as you're filtering, as the human filter of the cases that you All right, so real quick, the actions appellate courts take right here. First, appellate courts give a holding. They make a holding. They say, yes, we affirm what the lower court says, or no, we don't agree with what happened at the lower court. We're going to reverse it and remand it. If we reverse only the case, we change the decision. So there are 3 different actions, more or less, that the appellate court can take. These are the most common, and so those are holdings. They affirm it, they reverse and remand what happened at the lower court, or they reverse the lower court. And so those are the actions that the appellate courts take. All right. So thank you for listening. These are the things, this list is just like the list I showed you when we got started, so I won't beat a dead horse. The PowerPoint presentation also has some notes in the lecture notes, so you might want to print those out and have them ready with you as you take this little quiz. It's a 20-point quiz about this PowerPoint presentation. As I pointed out when I started the presentation, it includes discussion about the textbook Researching the Law by Amy E. Sloan, the textbook that you bought for this course. The quiz will also include that legal authority chart. Well, it won't include that chart, but it'll also include that Pardo versus State case. So I'm going to post that to the course. And there is the legal authority chart that I showed you in the previous slide that had the types of authority and when they're considered mandatory and when they're considered persuasive. So please take a look at all of that, take the quiz, and let me know if you have any questions about what you've learned. This is a really important threshold step into research, is understanding this, and hopefully the quiz will also help to reinforce that. Thank you.